about the jurisdictions of the Supreme Court. The jurisdictions of the Supreme Court. Basically, we are talking about the powers, the different heads, different types of powers. And the first jurisdiction of the Supreme Court, we call it as the original jurisdiction. Article 131 of the Constitution talks about the original jurisdiction of the Supreme Court. See, original jurisdiction means only Supreme Court can take up certain cases. No lower court can take up such cases. Okay. So, only Supreme Court can take up certain cases. No lower court can take up such cases. Okay. So, the lower courts are excluded from such cases. Okay. So, only Supreme Court has this power. Similarly, even high courts have certain original jurisdiction. That means no lower court below high court can take up that case. It can be taken up subsequently only in the Supreme Court. So, please understand that nobody below that case, that level, Supreme Court, all the courts are below. So, Supreme Court is the apex court, the highest court. Certain cases can be taken up by Supreme Court alone. No lower court. You cannot go to the lower court for that. What are those cases? Number one, the dispute between Government of India and one or more states. Which are those cases? Number one, the disputes between center and one or more states. Okay. So, center versus the states, or number two, center plus some states on one side versus other states, or one or more states on the other side. So, Government of India and some states on one side and the rest of the states or one or other states on the other side. And number three, or between one or more states on one side, states versus one or more on the other side, one or more states on the other side. So, states versus states. So, in all these cases, suppose we didn't know river water sharing, the Kaveri water dispute. See, Karnataka versus Tamil Nadu, or Karnataka and Tamil Nadu may be on one side, or other Kerala and Karnataka may be on one side, Tamil Nadu and maybe Puducherry on the other side. So, between the states dispute, Kaveri water dispute, it can be taken up only in the Supreme Court. No high court can take up that case. So, this is what is called original jurisdiction. But there is an exception to the original jurisdiction. So, exception to Article 131. But provided that said jurisdiction shall not extend to a treaty, extend to a dispute arising out of any treaty, provided this dispute has not arisen from a treaty or an agreement or or any instrument, a treaty or agreement or any similar instrument which has entered into before the commencement of the Constitution, which has entered into before the commencement of the constitution. So, this if the provided that such a jurisdiction, see, original jurisdiction is not exception, we are saying exception is provided that this dispute has not arisen. That means if the dispute has arose from an agreement which is signed between the two states, or between the center or the states, or between the two states before the commencement of the constitution, then if it has happened like that, if it is because of an agreement or a treaty or an instrument which is signed before the commencement of the constitution, then original jurisdiction is not applicable. The meaning is, if it is entered before the commencement of the constitution, original jurisdiction is not applicable. If this is because of a dispute is arising out of a dispute which is signed before the commencement of the constitution. But if it is after the commencement of the constitution, all disputes between the states or between the center and the states, everything will straight away come to the Supreme Court, no lower court can take up the case. So, that is the first jurisdiction of the Supreme Court, that is called original jurisdiction. Only exception is if the treaty or the dispute is because of a treaty or an agreement or an instrument is signed before the commencement, then there is no original jurisdiction. It will continue as it is, the way it is coming up from the high courts, it will come to the Supreme Court. Through the normal procedure will be followed. Second, vital jurisdiction of the Supreme Court is the writ jurisdiction, which you have already seen. The writ jurisdiction. The writ jurisdiction is provided through Article 32. It imposes a duty on the Supreme Court to enforce the fundamental rights. Under this article, every individual has a right to move the Supreme Court directly if there has been an infringement of his or her fundamental rights. And it is the duty of the Supreme Court to ensure and protect the fundamental rights of an individual. The writ jurisdiction sometimes is referred to as the original jurisdiction of the Supreme Court, but in the strict sense, original jurisdiction means only those cases which are of federal character in nature. In some books, they may say writ jurisdiction is also an original jurisdiction, but it is not the case. Original jurisdiction word is used for federal character, where there is a dispute between the center and the states or between the states. Anyway, so again, writ jurisdiction is available for the high courts also. Please don't forget. So anyway, Article 32, the second one is the writ jurisdiction. Number 3 is the appellate jurisdiction. Appellate jurisdiction. The appeal. Appellate jurisdiction means the final appeal of all the cases in India lies in the Supreme Court. Supreme Court has the right to hear the final appeal in the Supreme Court. Okay, there are the 3, 4. One is constitutional. Constitutional means in constitutional matters, an appeal lies in the Supreme Court if the High Court certifies that the case involves a substantial question of law as to the interpretation of the Constitution. So, when normally the High Court will certify if there is a constitutional matter is involved. Even if the High Court has not given a certificate, even then Supreme Court can take up the matter as special leave petition. Special leave petition. See, special leave petition means for any case which has not been certified by the High Court can be taken up by the Supreme Court by itself. This is what the meaning of the special leave petition. If the court feels that there is a substantial constitutional case involved, Supreme Court can take up this case by itself even if it is not certified by the High Court. Let me clarify once again. I am saying the Supreme Court has the right to hear an appeal in all the matters, in all the three types of cases. One is the constitutional cases. In a constitutional matter, an appeal lies in the Supreme Court. Normally, the High Court will certify and say that this case involves a substantial question of law and the Supreme Court will clarify. Even if High Court has not given the certificate, Supreme Court can take up this matter and look into the case under the special leave petition. That is the meaning of what I said. So, in constitutional matters, then in civil matters, I already talked about what is civil and criminal and all. In all civil cases, an appeal lies in the Supreme Court if the High Court again certifies that the value of such matter of dispute is more than 20,000 rupees. So, any dispute whose value is more than rupees 20,000, High Court will automatically certify, and the appeal, there is a right to appeal in the Supreme Court provided the High Court certifies. Again, if the High Court fail to certify, a special leave can be there in this case also. And in the criminal matter, the third is the criminal matter. So, we have the civil, the constitutional matter, then the civil matter, then the criminal matter. And again, in the criminal cases, an appeal lies to the Supreme Court if the High Court on appeal reverse the earlier acquittal. So, death sentence or any of these cases, Supreme Court has a right to hear the appeal in the criminal matter also. So, all the three cases, in case High Court refused to certify, then the Supreme Court enjoys the special leave petition. So, Supreme Court under Article 136 enjoys the power of granting special leave to appeal from any judgment. Article 136 of the Constitution provides Supreme Court with the power of special leave petition. Okay. So, it can be challenged in the Supreme Court. An appeal can be there in the Supreme Court even if the High Court refused to give a certificate saying that you can go to the Supreme Court. That is the main. So, in constitutional matters, in civil matter, in the criminal matters, Supreme Court has a right to appeal or a right to hear that case. Final appeal lies in the Supreme Court according to the need. So, this is the third jurisdiction of the Supreme Court, that is the appellate jurisdiction. A fourth jurisdiction of the Supreme Court, very interesting one, it is called the advisory jurisdiction. This is, Article 143 of the Constitution, Article 143. This is one of the salient features of our Indian Constitution, which is not there even with the US Constitution. US Supreme Court has no advisory jurisdiction. They have no advisory jurisdiction, but Indian Supreme Court has advisory jurisdiction. The Supreme Court, the President of India can consult, this is a consultative mechanism. Consultative mechanism we can say. The President of India can consult the Supreme Court, can ask for an opinion, can advise. So, Supreme Court can place a question of law, or a proposed legislation or a fact can be placed before the Supreme Court. The President can ask for an advice, for an opinion, which is of public importance. See, suppose the Parliament is planning to make a law, and if it is going to be a controversial one, or if the Parliament knows that there can be a lot of legal issues involved in it, even before the law is passed, this law can be presented to the Supreme Court for an opinion. We can ask the President can ask for an opinion. Please tell, presidential reference, an opinion, an advisory jurisdiction. And the very interesting thing is, the Supreme Court is not bound to give an opinion or give an advice. Okay, give an advice. So, the President can ask for an advice, advisory jurisdiction under Article 143, but the Supreme Court is not bound to give an advice. Similarly, the President of India is not bound to accept the advice. the President of India, that means President of India means the Council of Ministers, because Council of Ministers through the President is asking the question. The President of India is not bound to accept the advice. It's not that we asked an advice and Supreme Court gave the advice, so the Parliament or the Executive has to follow that. No. Supreme Court is not bound to give the advice, but President of India also is not bound to accept the advice. But there is an exception to this. Exception to Article 143. Exception is if the question asked by the President is something related to a treaty or an agreement or a covenant, if the the dispute or the question is related to a treaty or an agreement or an instrument or a covenant arising out or which was entered into or executed before the commencement of the Constitution, entered into before the commencement of the Constitution, entered into before the commencement of the Constitution, then the Supreme Court is obliged to give an advice. Supreme Court cannot deny this. Then the Supreme Court is obliged to give an advice. Supreme Court is obliged to give an advice. Supreme Court cannot deny this. They cannot refuse. Supreme Court cannot refuse under Article 143. Otherwise, Supreme Court is free not to give an advice. During P.V. Narasimha Rao government's time, P.V. Narasimha Rao was a very, very, very shrewd politician, very smart politician, even though he never used to speak much. He used to speak very less, but very, very sharp in his mind. He very, very cunningly, under Article 143, under advisory jurisdiction, this was immediately after the demolition of the Babri Masjid in 1992. P.V. Narasimha Rao asked or rather the President of India at that time, through Article 143, asked a question to the Supreme Court. Very simple question. The question was there a temple existed before the construction of the Babri Masjid Mosque? This is what nobody knew. Even today we could not prove it, even though the judgment was given and gave the land to the Hindu community. But there is no clear evidence. Even Archaeological Survey of India failed to prove that there was a temple existed before the construction of the Babri Masjid, almost 400, 500 years before, whatever it is. So, Narasimha Rao asked this question to the judiciary, to the Supreme Court. Tell me, a chota sa doubt hai, I have a small doubt. Was there a temple existed before the construction of Babri Masjid? This was a very cunning question to the Supreme Court. Rao what he wanted was, if the Supreme Court says yes, there was a temple, then the Rao will immediately say, Dekho, there was a temple, so let us hand over this land to the the Hindu community. Suppose the judiciary says no, there is no evidence and there is no temple, then Rao can easily say Babri Masjid should continue with the Muslim community. But sensing this, this trick in this question, Supreme Court, what they did is, the Supreme Court even acted even more smarter. Supreme Court refused to give an opinion. Supreme Court, using Article 143 provision, Supreme Court refused to give an opinion or an advice, saying that we don't know, I don't know. He was asked, Supreme Court was asked a question, was there a temple before the mosque? Supreme Court said, I don't know. Matter was over. So that is a very, very interesting Article 143 question, which Supreme Court refused to take up. So Supreme Court has the right not to take up, and the executive and the president has the right not to accept the advice given by the Supreme Court. Finally, so fifth jurisdiction, that is called the revisory jurisdiction. Revisory jurisdiction. The Supreme Court under Article 137, Supreme Court is empowered to review any judgment or order made by itself and change it. Okay, Supreme Court has the right to change its own view and opinion, especially to remove any mistake or an error. To remove a mistake or an error committed by the judiciary, or an opinion given by the judiciary earlier, they have the right to review it, which is called the revisory jurisdiction. That means Supreme Court can change its own opinion. Supreme Court can change its view, but once the Supreme Court give a verdict, that judgment and order passed by the Supreme Court is binding on all the courts in India. It is binding on all the lower courts in India. Any judgment given by the Supreme Court, it is binding on all the courts, but it is not binding on itself. You just remember Golaknath case. Golaknath case 1967. Supreme Court declared that Parliament has no power to amend fundamental rights. Then Keshwan Bharati case. Supreme Court reversed its order in 1973. What was said in the Golaknath case, and they reversed it and said that Parliament can amend fundamental rights or any part of the Constitution, but subject to the basic structure of the Constitution. So suddenly Supreme Court came up with the idea of basic structure of the Constitution in 1973. This is what we call revisory jurisdiction. Supreme Court can revise its own view, its own opinion. It can change its view. Supreme Court is not bound by its own opinion. It can change and reverse, so that it can correct. And when a new, now earlier the rights of LGBT, lesbian, gay and all, it was not accepted. It was seen as a crime. It was seen as a deviant behavior. But now Supreme Court is saying that Section 377 and all is unconstitutional. Supreme Court has said in many cases, even the rights of the transgender community, what was said earlier and what is now Supreme Court, even Supreme Court has recently said right to privacy, which is not accepted earlier. Remember, habeas corpus case, 1976, Supreme Court said that there is no right to life during emergency. But in 2017, five-judge constitution bench has overruled the 1976 judgment and declared that right to life is a fundamental, is a basic structure, and they have overturned and override, or they wrote a new law or a new judgment declaring what was said in 1976 is absolutely wrong. This is what is called revisory jurisdiction. So Supreme Court has 5 jurisdiction. Original jurisdiction 1, where only Supreme Court can take up such cases, no other lower court can take up that case. Writ jurisdiction, appellate jurisdiction, including even the court martial cases. I forgot to mention, even in a court martial case, where an armed forces personnel is punished by the military court. Court martial means a military court case, final appeal can be there in the Supreme Court. Supreme Court has the right to hear even a court martial case. Right to appeal, and appeal in terms of constitutional matters, in terms of civil matters, in terms of criminal matters. Then Supreme Court has advisory jurisdiction, a unique one, where the Supreme Court is not bound to give the advice and the President is not bound to accept the advice, but yes, advisory jurisdiction, and finally revisory jurisdiction. What is a court martial case and all? I will take it up separately in another video. So, there are 5 jurisdictions under Supreme Court, or under 5 different powers under the Supreme Court, which are very vital for the functioning and upholding of the law of the land. Upholding the constitution, we need these 5 jurisdictions for the Supreme Court.